от сложных и странных российских конкретных примеров и реалий мы сейчас перейдем к очень вдохновляющему, оптимистичному делу, к попытке создания европейской рамки и к той самой этической хартии использования искусственного интеллекта в правосудии, которая была уже ранее упомянута. И эту проблематику, эту работу нам представит Клементина Барбаро, которая представляет специализированную профильную Европейскую комиссию по эффективности правосудия. Welcome. Would you like to speak from there? From here?
Well, first of all, thank you very much for inviting me. It's a real pleasure of being with you today. Special thanks in particular to Boris Civilix, who helped me make the link with the organizers and of being present with you today. The good thing of intervening in the afternoon is that you find out that many of the things that you wanted to cover have actually already been addressed or dealt with by previous speakers. But this is actually very good because it will allow me to speak about, in fact, new developments which had not yet happened at the time I shared my PowerPoint with the organizers. So I will be perhaps more quick on certain aspects which have already been addressed, and I will also be able to talk to you about these new developments. So first of all, a small word of introduction about the CEPEJ, the European Commission for the Efficiency of Justice. This is a body of the Council of Europe which is composed of representatives from the government of the Council of Europe 47 member states. I was looking, of course, Russia is a member of the CEPEJ. The member of the CEPEJ is Mrs. Alexandra Dronova from the Ministry of Justice. And so the CEPEJ originally has been established with a view to promoting the efficiency of justice at the level of the 47 member states. It has been very well known in particular for trying to assess the efficiency of judicial systems, and it publishes every 2 years a very comprehensive report which in fact provides the description, a very detailed picture of many structural aspects of functioning of judicial systems. So you can find a variety of information there, such as, for instance, the number of human or financial, the human resources of judges, prosecutors, lawyers in all the 47 member states. You can find information about the budgets for the judiciary, the level of computerization of judicial systems. So it is really a very rich source of information. But today, I'm not here to talk about this very well-known strand of the CEPEJ activity, but rather to talk about this more recent work, which was adopted by the CEPEJ in December 2018, this European Ethical Charter on the use of artificial intelligence in judicial systems and their environment. So, and the first thing I would like to say is that this is the first text, not only at the European, but also at the global level, which tries to define a set of criteria and principles which should guide the integration of artificial intelligence in judicial systems. So there are plenty of charters. There has been a recent study of Oxford University about the about the charters and soft frameworks which exist around the world. So this charter as a specificity is the only one which tackles in particular the issues related to the use of AI in judicial systems and not in the society, for instance, at large. So now let's start. So first of all, I would like to mention what is the background of this work. This work is the result of observation of a series of developments in a number of Council of Europe member states. The first one is the fact that judicial decisions are made more and more available in the form of open data, so which in a nutshell means in a format which is readable by computers It is just not enough to publish the decision. It has to be published in a given format. And the judicial decisions then become the fuel of artificial intelligence, which can analyze them for very different purposes. And then, of course, one other factor which we were particularly interested in was the rise of this new market of these legal texts. Christina has referred to it this morning, which is growing exponentially in Europe. And so, not surprisingly, these legal texts were literally knocking at the door of judicial policy makers and try to promote their tools and services with a view to their integration into the judiciary. But the real issue here is that these two new tools raise new challenges, and judicial policymakers, in most cases, were a bit afraid of promoting their widespread introduction at the national level. So they turned to us in order to get some guidance, and this is what we try to do with this work. And I also would like to say that today, in reality, the use of artificial intelligence in Europe is not, let's say, is still in European judicial systems, sorry, it is something which is not, let's say, for instance, adopted by a member state. There are small testings here and there, but we are still in a phase where we need still to see, let's say, a global introduction in the judiciaries. Of course, it is different for the private profession, where perhaps there is a much widespread use than what it is the case in the public sphere. So, with this work, we tried to, first of all, to make a scientific analysis of AI tools and services. And when I say scientific, I want to say that we didn't think just as lawyers. In reality, our work was the result of, the fruit of a multidisciplinary approach, and we tried to work together, lawyers, mathematicians, statisticians, because some of these limits of these applications, they are actually very well known by computer scientists and by statisticians. So we needed to know where the problems are, let's say, in the general functioning of these tools, in order to see whether they are fit for the needs of the judicial systems. We wanted also, of course, to help identify the positive solutions, because we believe that there is a real potential there to be explored, but at the same time also advise on certain safeguards, on ethical aspects which need absolutely to be considered when using these tools. So we see here some examples of applications of AI as we could observe it throughout Europe. You have case law search engines, where the possibilities of performing a better case research are perhaps amplified than what it is the case with the existent legal research tools. Artificial intelligence can be also used as a tool for a better justice administration. In particular, it can help follow on a real time the performance of courts, and then can help decision makers, for instance, to help courts which are facing situation of backload and try to provide, allocate resources differently. We have the example of the chatbot, so providing advice to litigants. This is the case in Latvia, for instance, where there are testing of chatbots to advise litigants on the submission of their complaints before the court, and the chatbot can say, for instance, to the litigant, look, you are already out of time. There are statutory requirements, you cannot lodge your claim before the court. And then there was this application of predictive justice, which in particular was, we looked really at it very carefully, both in the civil and administrative field, but also in the criminal field. Here you can see an example of one of these predictive justice softwares. What it is, basically, it is the estimation of the likelihood of a judicial response by a court to a given demand put forward by the party. So you can say, you enter the specificities of your case, its subject matter, what is the court in which the case is going to be brought, and then this software calculates the likelihood, how the judge could potentially address, and decide on a given case. So, first of all, we really thought about whether the expression predictive justice was appropriate, because when you talk about the prediction, and you have, we examine in particular even the Latin roots of this work, predictare means say something before it happens. And the prediction, we remember it all from our studies, it was something which was in general a supernatural skills of oracles who could predict the future. Whereas we find in reality that these tools, they are based on the observation of empirical data, they are based on the observation of judicial decision of previous courts rendered on a given matter. So, first of all, first conclusion, we find that this term is a little bit misleading, and we should more talk about forecasting than real prediction. And it was particularly interested, in fact, also to analyze and to see how these tools in reality function. And we had the opportunity in particular to look at a study which was issued, I think in 2016, yes, about, by the University College of London about predicting the decisions of the European Court of Human Rights. The merit of this study is that it is public. So we could really and this is actually, it's not insignificant, because one of the problems of these tools is that sometimes you are not really given the possibility to access them and to see how they function. There is a real issue of transparency behind. But in this case, the study was very, very well argumented, and in fact, with a quite striking conclusion that there was a possibility from the software to predict rightly how the court would decide on a given case in the 79% of the cases. So we tried to a little bit to examine what was the technique used, and so for those of you who are computer scientists, there were basically two techniques which were used. One was the automatic natural language processing, so the ability of the machine to understand human language. And then there was the technique of machine learning, which is in fact the ability of the machine to find the correlations in the big amounts of data and to issue predictions out of it. And then the combination of these techniques allow to classify, let's say, the decision, they're able to classify, the lexical groups according to their frequency in violation or non-violation decision. I will show you this. This speaks more clearly about. So you can see there are a group of words which you can find more frequently in violation decision. There are other groups of words which you can find more frequently in non-violation decision. I come back to this slide before, just to say that in reality, the machine was much more accurate when it was looking at the facts of the case. In this case, really, the rate of accuracy was 79%, but then it fell down at 62% when the machine was analyzing the legal application of the convention. So it was analyzing somehow how the provisions of the convention should be applied to this particular case. And which in fact brings us to some conclusion. The first conclusion, there is not an understanding by the software of the legal reasoning which is made by the judge. What it is used, it is a statistical approach, okay, and a probabilistic approach. And then what it is also the machine cannot do is try to explain the meaning of the law or even to predict the behavior of the judge. This is something that sometimes you can read, that the machine learning will enable you to detect whether judges are racist, whether they have hidden biases, and so on. We think that actually this is not true, because and this is because the very nature of the judicial decision. First of all, you see, the machine functions very well with the data such as figures, numbers, and so on. But it is much more difficult for them to analyze all the different causalities which are behind the judge's decision. Some of them, some of these causalities may not even be made explicit into a judicial decision for a variety of reasons. Perhaps the judge does not have enough time because he has to deal with a huge backlog of cases. Perhaps he has already some hidden assumptions in making his decisions which relate perhaps to the specificities of the jurisdiction. So in our opinion, in reality, the results of these predictions, they are not as accurate as they would pretend to be. So, and here, once again, I come to the fact that a court decision is in reality an imperfect raw material for computers, because it is still something where there is lots of discretion, lots of human discretion is made in a judicial decision. First of all, in the selection of facts, because the parties will come with different claims and the judge will make a selection out of them. Then also the process of application of the law, it is something which is not fully rational. I mean, sometimes there is a really intertwining of different sources which need to be applied to a particular situation. And even what it is called as a syllogism, so let's say a cause-effect modelization of the reasoning of the judge, it in reality, in most of the cases, it is something which is done ex post. So it's far from being sure that all let's say the reasons which have pushed the judge to decide in a given manner are really made explicit in the decision. So this is why also the two testings which have taken place, for instance, in France, in two courts of appeals about the use of these tools, they have not really been they have not been very positive. The judges have concluded for a lack of their added value for their activity. So we think overall that perhaps there should be at least caution in seeing how these tools can be used in reality and how can be effective for use in judicial systems. And also when it comes to let's say, their application in civil and administrative matters, there are also some issues we should carefully look at. First of all, what is the place that these statistical tools should have in the decision-making process of the judge? Because the judge is bound to apply the law. Here you have a new, let's say, quantitative norm based on numbers, based, let's say, on the quantification of probabilities of judicial response that enters somehow into this judicial and decision-making process and in the process of application of the law. But so it's something that's completely external which comes in. And particularly, you know that these tools, they are based on the analysis of previous decisions. So their effect naturally is that they risk crystallizing the case law, of making its evolution not possible. There are also some inherent limits which which are relevant, for instance, to the evolution of society vis-à-vis of complex societal issues. For instance, in Italy, we had a couple of weeks ago a very important case decided by the Constitutional Court about end-of-life treatment, in which there was a completely a revolutionary shift made by the Constitutional Court. These, let's say, feelings of evolution of the society vis-à-vis certain peculiar matters are very hard for a machine to be made. And also something which we are a bit concerned of, it is the so-called performative effect. So that the judge, you see it from this scheme here, the judge will look at the solution which is proposed by the computer, and he will reproduce it automatically. He will not perhaps think, he will rely on the machine, and he will not look anymore at the peculiarities of this case, with the result that the system continues to fulfill itself always with the same result. So these are the issues, of course, which we identified as being problematic, but we also thought that there are some uses which need to be encouraged, and in particular, those related to the case law research. Again, we think that there is a huge potential and that the legal research can be performed much more quickly and much more effectively than it is the case now, thanks to these tools. And then there is also possible use, which perhaps is more outside the justice system, in fact, but which is the online dispute resolution, which happens, for instance, in private platforms. Think, for instance, when you have a dispute with a big giant such as Amazon, you know, and then you will not settle your claim of perhaps a few dollars or a few euros in front of a court. You will just try to have it assessed through the platform, and then in this case, you might have in the future, if it's not the case already now, an algorithm providing you an amount for compensation. So I think this is inevitable. This will happen whether or not we want it. So what it becomes really essential is to make sure that there are safeguards which are being given to the users, because the users, who is not a specialized user, a lawyer, will just accept this passively without knowing on which data the algorithm has been filled upon, you know, what are the data, whether he has the possibility to go to have the assistance of a lawyer or a judge. So we need to make sure that even in this space which are outside the judiciary, there is a possibility that the guarantees, fundamental guarantees, such as the access to judge or the lawyer, are upheld. Then here there was all the set of my presentation, which had been, let's say, already been presented by previous speakers. So I will, and also since we don't have much time, I will go quick, perhaps on that. Here we have an example of, let's say, of predictive policing, which was already presented by Boris Chilevics. So let's just really focus on the risk assessment tools, which still we analyzed, even though in reality there are only a few examples of application in Europe, and in particular in the UK. Still, this HART example was quite interesting for us, you know, to try in a way to analyze its implications, even if still today, as I said, it's a small scale. Let's say, example in Europe. So actually, it is this. So we have already said that these tools, they are risk assessments. They are mainly used in the field of custody, sentencing, and execution of criminal sanction. And again, they are used with a view to helping the judge to determine whether a suspect is at low risk, medium risk, or high risk of committing a crime. What I find it interesting in these tools is that, you know, the risk factors in reality, they are not specific, let's say, to the individual, which is under custody, for instance. In fact, the machine reads thousands of previous custody decisions, and it is able to identify some transversal elements which are common also to previous categories of offenders. So, and then it's interesting because then you have issues which are looked at, which are, for instance, the employment, the level of education of the person, the criminal history, and so on. So what it is really problematic for us, it is that at the end, you know, we mentioned earlier the case of Compass, which has been found to be discriminatory and in particular to overestimate the chances of recidivism by Afro-American communities. So the problems which we see here is the risk of resurgence of a certain determinism in criminal matters. Here you see examples of Lombroso, you know, where in the 19th century there was the attempt to define the profile of a criminal based on his appearance. Here it's not anymore the appearance, but it is somehow some statistical factors related to the community to which a given person belongs. But still, so first of all, also what is the individualization of the sentence? Because at the end it is you're belonging to a certain group which matters. And then also, of course, the risk of discrimination and mistakes. And also, here, sorry, this is a funny picture, but it is just to explain you see the, I mean, it's something related to the heart example which was mentioned before. And the fact that this system, it basically designed with a view to detecting high risks profiles and detecting false negatives. So you see here in this, you know, all the Star Wars saga, so you have a subject, which is Darth Vader, if I remember well, which was not felt as being dangerous for the society, but in fact it turned to be. And you have another one, which on the contrary was somehow perceived at the beginning of the saga as dangerous, but in fact he didn't commit any crime. So the issue is here, in my opinion, you know, it's how you calibrate these tools, because it is clear that, I mean, first of all, I find it very questionable that fundamental choices are left in the hands of private companies. Because here it's a matter of calibrating, on one hand, the risk of dangerousness for the society and impeding the commission of crime, but on the other hand, you have, you know, the preservation of, for instance, of the rights of the accused, the presumption of innocence, and so on. So in this, of course, when you want to let's say, to detect, you know, to detect false negatives, you know, when you want to understand who is likely to commit a crime, then the number of false positive augments, because you want, you know, to include more people in this likelihood. So I find it very questionable, in fact, that these fundamental choices are left to the end of private operators. There is an overall issue of transparency of these tools in the framework of the criminal trials, because in the case of ProPublica, it was not easy, in fact, to, you know, for the NGO to know how the campus algorithm was functioning, and also, last but not least, what are the effects of these tools on judicial decision making? Because in reality, the risk that of a delegation of a responsibility towards the algorithm is very high, and especially in countries where the guarantees of judicial independence are not very strong, you know, it could be very, in a way, easy for the judge to say, it's not my decision, it's a decision made by the machine. So I will, there are nevertheless some uses which are possible. In particular, AI could be used, in fact, to collect information which is nowadays scattered in many different institutions. I use it in favor of the accused. And then I will finish really with a few words about the charter, because all this study, in fact, led to the elaboration of a number of principles, which I will present to you now. So principles which are, first of all, addressed to policymakers, those who needed to decide on the introduction of these tools, but also for the private companies, for those who design these tools. And the first principle, there is one more slide, where you can see, first of all, good news, the charter has been translated into Russian. So you can find it available on the it is available on the website of the CEPAJ. No, this is very important because you know, we need to make our documents accessible to all the member states. And so here you can see the different parts of the charter, including this in-depth study. And then we start with the first principle, the principle of respect for fundamental rights. So make sure that the design and implementations of artificial intelligence tools and services compatible with fundamental rights. So here it is a very short statement, but in reality, if you look at the charter, we first of all, we talk about more concretely about what it means. For instance, it is the human rights by design, how you study, for instance, the impact that these tools may have on human rights and data protection. We have also restated certain guarantees which are particularly important, which are the access to a judge, the access to a lawyer, the independence of the judge. You have seen how these tools can somehow undermine them. The principle of non-discrimination, even if it's let's say, a human right, we thought of giving it a specific mention in the light of the problems which arise from the use of these tools in the criminal sphere. Then the principle number 3 is the principle of quality and security. It is really a principle about the quality of data and how you select the data. So what we stress is that we need, first of all, to use judicial decisions which come from public authorities this is not the case in all member states, because in some of the states, not all the public decisions are available in the form of open data, and for instance, sometimes there is even an unethical search for this decision by legal text. Then we want also to this data to be intangible. They should not be alterated until they are processed by machine learning, and they should be stored in a secure technological environment. Then the principle number 4 is the principle of transparency, where we really, here we have been more specific. We have been saying that, first of all, it's time to ensure that there is an oversight of these tools. There should be certification policies which should be put in place by member states. There should be audits by independent authorities. And we also say that there is a duty also of the legal techs, if they cannot disclose entirely, let's say, their trade secrets, at least to be honest about what these tools can do or cannot do. So this is also something which we call upon on the private sector. And then, last but not least, the principle under user control. This is basically the fact of being able always to come back to the original decisions. We don't want these tools from predictive to become prescriptive for the judge. So we should always try to find how they produce the results. It's again linked also to the transparency principle. So I mentioned earlier that I mentioned earlier that there have been some developments also since the time I sent my presentation. Well, first of all, one development is that on 14 and 15 of October, there was in Strasbourg the conference of the justice ministers of the 47 member states, and the charter was the most quoted instrument in their speech. So in all the speeches from the ministers, really everybody agreed on the fact that this tool should be used as the basis for integration of AI into judicial systems. Then something related, again, Mr. Cilevic said earlier, it's a bit generic. And this is why, in fact, now we are working on the operationalization of these principles. So we have started working with IEEE, which is the leading association in the definition of computer standards worldwide. And we are trying really to work with them on how to integrate the Charter's requirement in the technical specification. So when we are talking about transparency, what does it mean? Which kind of evidence must be provided? Because this is also at the end, you can ask many questions. We are asking a set of questions that the provider should consider, but also how do you prove that? So this is interesting because in a way, for us, it's a mean really to not only to try to encourage the private sector in developing solutions which are more ethically compliant, but also in trying to promote, in fact, it's also a way to, how can I say, to drive and try to try to encourage virtuous solutions, So if an algorithm, for instance, or an AI tool is not transparent, it doesn't respect the requirements of the Charter, then it should not be used, you see? Also, one more thing, I'm always in debates everywhere when everybody asks me, but don't you think that it is better to have a judge, do you think that it's better to have a human judge or a robot judge? So this is the question I've been always asked, and if I may say something, I think that the question is put in the wrong terms, in the sense that we have values which underpin our judicial systems and which have been existing since centuries. For instance, the right to access to a judge, the right to access to a lawyer. So, in my opinion, we should not give up these values just because there is a new technology, as promising as it can be, and also we should also always keep in mind that AI is a mean and not an end in itself. I would like to have AI to help me as a judge to have better informed decisions, and to reach better conclusions. So this is why also explainability becomes so important. It is not enough, in my view, that a system is accurate at 98% if I still don't know how it got to that result. And if there is, still you are not able to explain the 2% which is missing. And last but not least, we have been talking a lot about the need for regulation. And it is true that we have seen a proliferation of ethical frameworks, which have been a good start for the discussions, in my view. They have helped identify real problems and concerns, but which have the limit of being not binding, and of course, and not even of being able to be checked when it comes to their effective observance by private techs. This is why the Council of Europe has made a step forward, and it has been decided to set up this new ad hoc committee on artificial intelligence, which aims finally to see whether we can make a qualitative shift. So to shift from non-binding principles to a kind of framework legislation. Perhaps this meeting will meet for the first time in Strasbourg in 15 days. So we will see there what is finally the appetite of member states in that respect. Some of them are very eager to go to a regulation of AI. Some of them are less. So let's see whether there will be the possibility of emergence of a new, let's say, agreement among member states of some basic criteria that artificial intelligence should fulfill, and some level of controls which should be put in place by member state. So that's all I had to say. Thank you very much for your attention, and of course, any questions are welcome. Thank you.
Большое спасибо, Клементина. И вопросы?
First of all, thank you very much, Clementina. I never thought that one could speak about machine system in such an emotional and passionate way. И просто к сведению всех участников я хочу сказать, что текст Европейской хартии находится там же в материалах конференции на сайте Центра правовых программ на русском языке.
Клементина, спасибо. Thank you so much. Вопрос. Вы сказали, что из 888 решений по поводу возможности, значит, повторения преступления, лишь 10% полицейских согласились, что это действительно так. А вот интересно, мнения этих полицейских совпадали с реальностью? Или они ошибались еще больше, чем искусственный интеллект?
No, the fact is that the policemen, they did not agree on the classification of high risks in most of the cases. They disagreed with the machine. So I'm not sure whether you can really. I think that the matter here is actually a matter not of accuracy but of responsibility, because at the end, a police officer will have to respond about whether he has held a person unfairly in detention. An algorithm will not able to do that. So for me, this is the interesting point. And once again, there are all these debates about accuracy, whether machines are more accurate than human beings and so on. But once again, I would prefer the debate is put more in a logic of complementarity than in opposition. Okay, so if the machine can help me, and indeed are more precise for me as a human to reach a better decision, then there is a welcome. But to say that because they are accurate, they should replace the human judge, this is something which I have a problem with.
Вопрос следующий. Насколько люди, принимающие решения, если мы говорим о ситуации, когда искусственный интеллект не заменяет человека, но помогает ему принять решение. То есть существует инструмент, который дает советы и рекомендации, не знаю, там, судье, прокурору, сотруднику полиции и так далее. Насколько велики риски того, что люди, особенно нагруженные делами, работающие в такой очень рутинизированной атмосфере, будут просто, ну, как бы автоматически одобрять, ну, как бы он же сказал нам, искусственный интеллект, он же умный, что? Давайте, вот, насколько велик этот риск, как он оценивается и какие могут быть способы этот риск минимизировать, чтобы люди действительно включались в процесс, а не просто брали решение искусственного интеллекта и применяли без критической оценки.
I think that risks exist, and in fact there have even been studies which have published recently about that, on the fact that whenever you have an incentive of any kind to use algorithm in your judicial decision-making process, then you will use it, you know. So for instance, let's imagine a scenario in which one day a Ministry of Justice will issue a regulation in which you will make the use of these tools compulsory. I think that there are concrete risks, in fact, that people will apply them blindly. Then how to minimize that? First of all, it's involving judges and legal professionals in the debate around these tools, making them know what are the risks associated with their use, periodically review their utilization. This is very important because you can have a certain AI tool which is being introduced in the judicial system, and this is exactly the kind of issues you have to look at, you know, how they influence over, which influence they have over judicial decision making. So awareness of the stakes, periodical review of the effects. This is my answer.
Спасибо, спасибо. Я просто сразу подумал, какое количество безумно загруженных российских судей пользуются аналогичной помощью людей с естественным интеллектом и, в общем, с той же эффективностью, с теми же проблемами ответственности. Просто копирую. Кристина.
Thank you, Clementina. That was wonderful. Looking at predictive analytics, particularly when it comes to the use in court systems, we had two additional concerns. One related to the impact on the judges themselves. So if I'm a judge and I know that I find for the claimant 83% of times in this particular case, I've spoken to judges about this, and they would say, well, I'd probably look to find for the defendant a few more times. So the impact on the judicial decision making. And secondly, and this is more of a common law issue, but the concern that in any judicial system that is based upon precedent, that if outlying cases don't come to court, so if as a client I'm given some compelling information about the likelihood of my case to fail, let's say, you know, I have only a 42% chance of success, then actually that can lead to the seizing up of the rule by precedent and the way that our case law develops to reflect our developments in society. So those were two other issues that we were concerned about.
Any other questions? Mm-hmm. Mm-hmm. Okay. I have a little bit provocative question. Let's speak in Russian to the audience. Как вы относитесь, как бы вы отнеслись к идее, к последовательному проведению принципа свободы выбора пользователя, свободы выбора человека? У нас был опыт, и он сохраняется до сих пор, когда, например, у человека есть выбор между разными моделями суда, между судом с профессиональным судьей и судом с присяжными в некоторых случаях. Видите ли вы, например, перспективу свободного выбора человеком разных видов или разных комбинаций моделей? модель с судьей плюс помощником искусственного интеллекта, модель с искусственным интеллектом, чтобы человек мог выбирать. Или, когда позволят ресурсы, чтобы в каждом деле работал некий искусственный интеллект одновременно с судьей, была бы конкуренция решений, и человек бы выбирал наиболее приемлемое. Ну, просто из общих принципов там, презумпции невиновности или с принципов наиболее гуманного решения. Возможно ли такое, когда позволят ресурсы? Также могла бы быть, например, модель чередования в инстанциях. Например, сначала рассматривает искусственный интеллект, а в апелляции рассматривает живой судья. Или наоборот. То есть рассматриваются такие более сложные комбинированные модели. Спасибо.
Well, I think we are not in a very futuristic scenario because there are some countries like Estonia which are already introducing an automated processing of certain type of complaints under, if I remember well, 6,000 euros. So now they are automatically processed by an algorithm, but with the possibility of appeal to a human judge. This, I think, it's fundamental. We need to preserve. We need to make sure that this guarantee exists. And also, as you say, it's very also important to give the choice. I see in France for certain types of proceedings, now again we are going through to automatization, but still leaving the possibility to those who are not really at ease with the digital means to have a traditional way of access. We should not forget about the problem of the digital divide, you know, that we need, that at the end we risk end up having, you know, two types of populations, those who have access to these services and those who have not. So in my opinion, we need to be active on both. And last but not least, unfortunately, I think that, as I said, in reality, we are already going through algorithmic processing in online platforms. So this is already a reality. So perhaps people who go to this platform, they will never go in front of a judge. In return, they will have made a free choice, they will have a dispute settled quickly. I just, as I said earlier, would like that they know that there is a transparency on how these systems functions, and that there is always, you know, the free choice of trying to have the assistance of a lawyer or to go before a judge.
Thank you so much again, Clementina. Lena, the last question, yeah, please.
Благодарю за очень интересные оба выступления. И у меня вопрос к обоим докладчикам. Я прекрасно понимаю те возможности и перспективы, которые дает искусственный интеллект, но что меня действительно беспокоит, так это принцип публичного отправления правосудия. Мне довольно трудно представить, что в общественно значимом деле, в зале, где присутствует много-много публики, она будет удовлетворена наблюдением за неким механизмом, который осуществляет ряд совершенно непонятных действий, в результате которых на перфоленте появляется вердикт. Что говорит этическая хартия об этих проблемах? Идут ли дискуссии в российском юридическом сообществе на эту тему? Очень хотелось бы услышать ваше мнение по этому вопросу.
Спасибо, вы очень интересный вопрос ставите. И, к сожалению, этот вопрос пока не стоит остро в публичной дискуссии, связанной с цифровизацией уголовного судопроизводства. Но здесь пока не представляется, что судебное разбирательство будет публично механизировано, демонстративно механизировано, когда изумленной публике будут предъявлять вот эти вот манипуляции с кнопками. Пока речь идет об увеличении базы данных, которым может пользоваться судья, о возможности предложения каких-то вариативных решений, чтобы машина судье уже, может быть, в совещательной комнате предлагала несколько вариантов для решения. Но само судопроизводство остается в поле гласности. Здесь гласность, наоборот, может быть усиленная. Та же самая видеоконференц-связь, которая позволяет обеспечить не оглашением протокола допроса, а вот таким техническим допросом с участием непосредственным, пусть в другом помещении, пусть далеко на расстоянии, но зал слышит эти показания. И в этом смысле не рассмотрение дела предельно цифровизуется, а подготовка к нему и обоснование для судьи, профессиональная база данных. Вот пока стоит вопрос об этом. С искусственным интеллектом, когда мы созреем до его эмоциональности, психологии и прочее, будем как-то с ним общаться, пока не знаю.
I think it's a question which relates not only to the AI, but to the use of digital technologies in general in the justice system. For me, once again, I come back to the values. So we have a value which is the principle of equality of arms in judicial proceedings. So if an AI tool is going to be used in the framework of these proceedings, then we should make sure that the lawyers have the possibility to have access to it and to debate it in a contradictory manner in front of the judge. I think it's, once again, is a means. Digital technologies, they are means to achieve the purposes of justice, not more than that.
Спасибо. Но Лена сейчас фактически сформулировала очень серьезный технический запрос, заказ для айтишников, потому что мы не удовлетворимся внедрением искусственного интеллекта, пока не сможем посмотреть в его честные глаза из зала суда. Поэтому вот это специальное техническое задание. Честные и справедливые глаза искусственного интеллекта.
Just to spend a word to praise the work which has in fact been made at the UK, which has been very interesting for us, and I think that some of the findings that you are making about the fact that there should be a public registry of these tools, that there should be standardization, certification, and so on, it is really the direction where we need to go in terms of more accountability, let's say more transparency.
Спасибо большое. Мы на самом деле двигаемся по графику, поскольку часть коллег из последней части попросила снять их выступления, поэтому у нас есть запас времени, и у нас сейчас есть 30 минут для того, чтобы до 15:45 воспользоваться своим фундаментальным правом на кофе.